Hello, I'm Jorjana Marx. I'm an attorney with Oklahoma Senior Law in Tulsa, Oklahoma. We are an elder law firm, and specifically we do estate planning for Oklahoma seniors. We do Medicaid planning to help with transitions to nursing homes, and we do VA aid and attendance planning for our clients as well. So I come on here every week and I answer questions that we are being asked by clients and potential clients, and I like to talk about them with you. Sometimes people join me on here, but sometimes they watch this later and follow up with questions. So if you have a question, either on the topic we're going to cover today or on something else related to estate planning for seniors or Medicaid or VA aid and attendance, then call us 918-901-7777, or you can send us an email. You can send it either to me. I'll get it if you send it to our information email, which is info, I-N-F-O, at oklahomaseniorlaw.com. And so today, let's see, what have I talked about in the past? I've talked about some of the questions we've been asked, which are, do I need a power of attorney? What is power of attorney? What's a HIPAA waiver? Let's see, how do I pay for a nursing home in Oklahoma and what the typical costs are? We've addressed those topics in the past, and I'm happy to answer those questions again for you if you want to know. But today I wanted to talk about something that I'm asked pretty frequently, or I see having been done already, which is, should I add my son or my daughter to the deed of my house? Because that sometimes seems like a simple solution to getting a little extra help, or maybe people are sort of trying to do some do-it-yourself estate planning, and they think, well, then I'll die, and my son will get my house, and it will all work out. But should you do that? My answer is no. Period. And thank you for coming. But to go a little further on that, why should you not do that? Well, once you have added someone to the deed of your property, you have given them ownership. Maybe it's partial ownership, but you've given them ownership of your property. And there are various reasons why you would not want to do that. First of all, once you give your kids ownership, that means they actually own a part of your house, the amount that you gave them. So let's say it was just you on the deed and you add your son. Well, now your son owns half of your house. And that means that half is his property. And if he is in a divorce, that half becomes part of his property in his divorce. If he files for bankruptcy, he has that property as one of his assets. If he has creditors come after him for various reasons, maybe car wreck or something like that, that is his property that is available for his creditors. So while you live in that house and you feel like it's yours and you're just doing this to help with ownership down the line, or if you pass away, you've actually opened up half of your home to your son's creditors possibly. So, that's a good reason to really think about not doing it. Another reason would be something, and this is more on a tax side, but the IRS has something that is called a step up in basis, which sounds a little confusing. But when you, if you get a piece of property that passes to you because of the death of someone else, then you get to own it at the value it's at when they pass away. So that's called a step up in basis. The basis is the value of the property. So let's say you gift something to your son and you have gifted it to him at the value that you bought it at. So here's a sort of extreme example, but let's say that you live on an acreage and you only paid $5,000 for that back in like 1950. But that's a great piece of property and it's 2020. And now that acreage is worth $100,000. So if you put your son on your deed, he will now own it at the $5,000 price, $5,000 value, excuse me. And if he goes to sell it and it's actually worth $100,000, that's a $95,000 difference on which he will have to pay capital gains tax. So if he gets it at your death, he gets it at the $100,000 price today. So that's another good reason to be at least be wary before you put someone on your deed that it's going to have a tax consequence in that way. Also, you've put his name on this piece of property and you've effectively gifted him half of your property, let's say. We're going to go back to that example. Technically, you have also made a completed gift to him for IRS purposes, and now technically you are supposed to file a gift tax return if the value of that gift is more than the allowable limit by the IRS. So that's another little complication to think about if you're, wanting to add someone onto the deed of your house. And then finally, what we often see is someone comes to us with a deed that they've put maybe their son on, and they want to apply for Medicaid. And for Medicaid, that is also a gift. And as I've talked about in previous videos, Medicaid is, they look to see if you have made any gifts in the last 60 months. So if you had put your son's name on the deed thinking, well, this will just go to him when I pass away, and it was in the last 60 months of when you need Medicaid, they are going to look at that and say, you made a gift, and that money basically could have been used to pay for your nursing home, and so they create a penalty period. And then, sometimes that's where we come in and clients say, Medicaid, they've already down the line, and Medicaid is someone from DHS is coming back to them and saying, we have a problem here because of this gift of your house. And so we have to help them deal with that. So if you are considering putting a child, your sister, someone on the deed of your house, you might talk to an attorney first and see how the situation is going to affect you and affect your family and affect any potential benefits that you might be interested in either now or, in the next 60 months, basically, since that's the Medicaid rule. This is the type of work that we do. We do estate planning for seniors, like I said. Sometimes that's just helping them figure out how their property will pass once they die, but sometimes it is helping them figure out how to deal with their property as they age. And one of the things that we think about here is, do you want to make a gift of that property? Sometimes you do. Sometimes that is a valid estate planning tool for a particular person. And because we do this all the time, we are looking to see what the effect of that will be if you need Medicaid or if you need the VA's aid and attendance benefit, which is a great benefit to help with the costs of care. So we look at this all the time. And I always like to touch briefly again, in case someone is still interested in this too, on how you can be qualified to get Medicaid to pay for your long-term care. Medicaid is a benefit that is basically health coverage for many people, but it also has a long-term care benefit for seniors. And the way you get qualified for that is, first of all, you have to be physically qualified, which means, there's a definition of that, but you basically need to have the type of care that is skilled nursing care in a facility. And then you have to be financially qualified. And there are different rules if you're single versus if you're married. There are different asset rules and application of them. So what we do is sometimes we have clients come in and they think, well, my husband or I might need a nursing home in the next 3 years or 5 years, or we just got a diagnosis. And so we're kind of worried right now. And we just need to think about this. We need to know what's coming. And so we will have them come in, or we'll talk on the phone with them and say, here's how it works. And they lay out their situation for us, and we say, here's how it's going to work with this situation that you've shown us. And we just offer them the guidance, and we are friendly with many of the facilities in northeastern Oklahoma. And so we've visited quite a few of those, and we have some good insights on different places. And so a lot of times we help families just with, what are the next steps, and where do you think we should look? And, we give them the resources, we tell them our experiences, and we tell them how the benefits work and whether they, might be available for someone. So that is how we help families that are dealing with the long-term care issue, and also with their planning, for their estate planning, for their assets, and for their families, and how to take care of people and how to take care of themselves when they're aging and dealing with some of the things that come with that. So today was a shorter video because we have a pretty solid answer on whether you should put someone on the deed of your house. Don't recommend it, but you know what? Might be an estate planning tool for you. So if you have questions about that, you should definitely call a lawyer. If you want to call one that is here on this video, that's me, 918-901-7777. There are 2 other attorneys with our firm. Todd Watley is a certified elder law attorney, and he has been practicing in this area for about the last 25 years, I think. And again, he's certified as an elder law attorney, and he has expansive knowledge on all the different situations people encounter. He, as well as the other attorney and I, are all VA accredited attorneys. And so that means we have the experience and the education to help families deal with some of the VA benefits. But in particular, the 3 of us deal with the VA benefit of aid and attendance, which is a benefit that helps with the cost of care for veterans and their family, their spouses in particular. And then the other attorney is Blaine Frizzell, and he's been an estate planning attorney and elder law attorney, mostly estate planning for the last 25 years, but has been working in elder law as well. And we are here in Tulsa, and we take clients in person. We'll also take telephone calls. We'll do Zoom videos or a FaceTime video with an iPhone. And, we accommodate a lot of situations, and, things are weird during COVID still. So we are taking all precautions to keep our clients and ourselves and our families safe. So we can make things work. If you have questions, you should just give us a call, or you can always contact us. I'm looking down to see if there's any way I can comment, but you can always leave a comment here and someone will address it, or you can send us a message. We're pretty good on the Facebook. So if you want to do it that way, we can address that too. So I hope this was helpful. If you have other questions, like I said, give us a call. Thank you.